is a lot of information that is tested on the California bar exam. So one way that you can tailor your study schedule so that you're studying most efficiently is to focus on the highly tested topics. So in this video, we're going to discuss the highly tested topics that frequently appear on the essay portion of the California bar exam. So as you can see from this list, there are 14 subjects that are testable on the essay portion of the exam. You will see 5 essays on the exam, so not all of this will be tested every administration. Sometimes California does what we call crossover questions, where they will include more than one subject in a single question. So it's possible that you'll see more than 5 of these subjects on your exam, but you very likely will not see all 14 tested in one exam. Sometimes California tests California law on their essays, and they expect you to know the specific California rules. Other times, they test just the general law, which is the same law you're applying on the MBE portion of the exam. And what we see is that they test different subjects differently. So some subjects, California does not frequently test California law. For instance, agency and partnership, contracts, con law, crim law, real property. In these subjects, California generally expects you to just discuss the general law. Now you'll notice that civil procedure here has an asterisk. Technically, California civil procedure is testable. So you are expected to be able to discuss both the federal rules of civil procedure and California's rules of civil procedure. And there are some distinctions here. But to date, they have only tested those California rules one time. So thinking about what is highly tested, the federal rules of civil procedure are highly tested. So these topics, we tend to not see them test California specific law. The subjects in which they do test California specific law include community property, evidence, professional responsibility, wills, and trusts. Here they expect you to know and apply California's law to these topics. If you take a look at the frequency chart, you can see that not all subjects are tested evenly. We've talked about this frequency chart before, but taking a glance at it in this instance, there's 2 things I want to point out. Number 1 is that some subjects are tested more commonly than others. For instance, in California, professional responsibility is tested almost every administration. So you are pretty much guaranteed to see a professional responsibility essay on the bar exam. That means that you're not wasting your time if you learn professional responsibility really well. You're almost guaranteed to be able to show off your knowledge of that subject. If you compare that to something like agency and partnership, which is not highly tested, you're not going to get as much bang for your buck if you spend a lot of time studying this particular subject. So pay attention to which subjects are most highly tested. In addition to spending more time on the highly tested subjects, you can also hone your skills further by focusing on the highly tested topics within each subject. So here I want to talk just briefly about some highly tested topics within each of these various testable subjects. Let's start with agency and partnership. So agency and partnership was only added to the California bar exam in 2007, and now they combine agency and partnership with corporations, and they call these subject business associations. So if you see something that California has labeled as business associations, technically it could be agency and partnership, or it could be corporations, or it could be a combination of both, which is also common. We went ahead and broke down for you those questions and analyzed when they tested agency and partnership and when they tested corporations. When they test agency and partnership, as we saw in the frequency chart, this does not come up very often, but they tend to test it the same way over and over. Within agency, The two things that we see tested are authority and vicarious liability. Authority is an issue when a principal is allegedly bound by what their agent did. And the rule is that the principal is bound if the agent acted with authority. So this is something we see in contracts cases. You want to see if the agent had authority to enter into the contract. And there are different types of authority. There's actual authority and apparent authority. And if you'll notice here, there are some green dates at the end of each point on this handout. The green dates represent the instances or the bar exams where that particular point was tested. So if you notice the green dates for actual authority and apparent authority, they're the same. So that tells me that when they test authority, they typically expect you to discuss all the different types of authority. So this is one common way they test agency. The other thing that they like to test is vicarious liability. And this asks when a principal will be liable for their agent's conduct in a tort situation. So when an employee, for instance, commits a tort, the employer may be vicariously liable for that employee's conduct. When they test partnership, the things that they like to test are, number one, partnership formation. So they ask, is there a partnership, or what type of business entity have the parties formed? It's very easy to form a partnership. There aren't many formalities. You don't need to file anything. You don't need an agreement. You're just looking to see if the parties intended to carry on as co-owners a business for profit. So if you can break this down, you can see why it makes for a good essay. You have to look at the intent of the parties. You have to look at whether they were carrying on a business for profit. And there's no clear-cut rule. So it makes for a really good essay. And that's why California has tested this a number of times. Another common issue that we see in partnership is partnership liability. Once you've formed a partnership, all the partners are personally liable for the obligations of the partnership. So they may give you a situation where the partnership is sued, and the question is whether the plaintiff can go after one of the partner's personal assets. And the partners are generally personally liable for the obligations of the partnership. The next subject we have is civil procedure. And as I mentioned at the beginning with civil procedure, almost every time they've tested civil procedure, they've tested the federal rules of civil procedure. They did test California's civil procedure rules one time. When they tested it in that essay, though, even the entire essay wasn't about California's rules of civil procedure. I would say maybe a third, maybe half, probably about a third of that essay was on California's rules. The rest was on the federal rules of civil procedure. So even if you weren't super familiar with the California rules, you still could have done really well on that essay. So what do they commonly test in civil procedure? One of their favorite things to test is probably personal jurisdiction. And they're looking for a very specific response when they test personal jurisdiction. So if you see this issue, you first want to discuss whether there's general personal jurisdiction by going over consent, presence, and domicile. If there is no general personal jurisdiction, which on essays, usually there's not because your essay would end there, the next thing to do is look at specific personal jurisdiction. Number one, for specific personal jurisdiction, ask if the long-arm statute confers specific personal jurisdiction. And then number two, you have to see if specific personal jurisdiction is constitutional. And this requires a discussion of minimum contacts. And within minimum contacts, you should discuss whether the defendant purposely availed himself of the benefits and protections of the state, and whether the defendant could foresee being sued in that state. You should also discuss relatedness, whether the lawsuit is related to the person's contacts with the state, and fairness. Is it fair for this person to defend themselves in this state? Subject matter jurisdiction is another commonly tested topic. Often when they test subject matter jurisdiction, they want you to discuss both diversity and federal question jurisdiction. More often than not, they test diversity jurisdiction. Federal question jurisdiction has not come up nearly as often, but it's still a good idea to mention both. Another topic that sometimes comes up on the California essays is removal, and we see this a lot of times hand in hand with subject matter jurisdiction, because the rule for removal is that defendants can remove an action from state court to federal court, and they're removing to the federal court that geographically embraces a state court if the plaintiff could have initially brought the case in federal court. Well, when can a plaintiff initially bring a case in federal court? When there's subject matter jurisdiction. So these two topics frequently go together, and I wouldn't be surprised to see them both tested together on an essay. Our third topic is community property. And community property, this is something not tested on the MBE. This is just an essay topic, and this is one that does test California law. So wherever you're learning community property for the bar exam, you are learning California's law. Community property is an essay that has a pretty distinct format whenever California tests it. What they typically give you is this fact pattern of a husband and wife who've been married for a while, they're getting a divorce, and they identify a number of items of property that need to be divided at the divorce, and it's your job to say who gets what. So in the call of the question, they often tell you what property to focus your attention on. And community property should always start with the presumptions. So you want to discuss the presumption for when things are separate property, the presumption for when things are quasi-community property, the presumption for when things are community property. So start with the presumptions, and then generally you're going to discuss things that change the presumption. So if the presumption is that something is separate property, has anything changed the characterization of that property from separate property to, let's say, community property, such as a transmutation, which you can see here is one of the highly tested topics. If there's been a transmutation, this is where the parties agree to change the characteristic of a particular piece of property. So they may change it from separate to community or community to separate. So you oftentimes have to go through several steps with each item of property that they identify and discuss whether it is ultimately separate property or community property and the effect that that has on the distribution of that property upon divorce. Another topic you can see that they commonly test here is debt. And what this means is that they test debt as a type of asset that's being divided. So who's responsible for the debt? And the rule differs depending on what type of debt it is. So they may test general debts, they may test tort debts, where let's say one of the spouses gets into a car accident and is sued for negligence and owes some money. They've also tested debts incurred prior to the marriage. So it's important to be familiar with these different rules for the different types of debt. Our fourth topic is constitutional law. This one, they can test a lot of different substance of constitutional law. So you'll see that they've tested the Dormant Commerce Clause, they've tested the Due Process Clause, the Equal Protection Clause, free speech, freedom of religion, both the Establishment Clause and the Free Exercise Clause. And oftentimes the call of the question will be open-ended, where they'll tell you that someone has brought a constitutional challenge and you have to identify the constitutional arguments that that person will raise. So being familiar with the different substantive arguments, which are listed here, that the person can raise is going to allow you to best spot all of those potential issues on this type of essay. I do want to mention the first issue that's identified here as highly tested in constitutional law, and that is standing. Many constitutional law questions begin with an issue about standing. They don't tell you to discuss it. It's not always super clear that you need to discuss standing, but it's a good idea to include a brief discussion of whether the parties have standing to bring this lawsuit, before really getting into the heart of these various substantive issues, such as the Dormant Commerce Clause, the Due Process Clause, the Equal Protection Clause. It appears that they often give points for at least a brief discussion of standing based on what we've seen from the highly scored student answers. Our next subject is contracts. Contracts is another subject that they test a wide range of things. I think with the MBE topics, they kind of assume that you're learning the entire subject anyway for the MBE portion of the exam, and so they tend to change it up with how they test these topics, and we see them testing many different things. For instance, in contracts, they very often test contract formation, and contract formation could be a huge part of the essay where you do need to go into a lot of detail with regard to whether a contract has actually been formed. Or it may be the case that it's pretty clear that the parties have formed a contract, and if you see that type of essay, it's still usually worth mentioning contract formation, and that contract formation requires an offer, acceptance, and consideration. Even if it's not a huge part of the essay, you may get some credit for at least briefly mentioning it and identifying the elements of contract formation. Another favorite of the California Board of Law Examiners is the parole evidence rule. We've seen this come up a number of times. This is only applicable if a party is trying to add a term from preliminary negotiations to a final written agreement. So as you're learning the parole evidence rule, what you're going to see is there are a lot of situations where it seems like the parole evidence rule applies, but it really doesn't. It won't bar the parties from introducing evidence into court because they're not trying to add a term from preliminary negotiations to a final written agreement. But you may need to discuss the parole evidence rule anyway. You may get credit for seeing those facts that seem to hint at the parole evidence rule and discussing in that instance why the parole evidence rule does not apply. They also like to test the distinctions between common law and the UCC, and particularly the duties and what is required for performance. Under common law, substantial performance is required, and once one party substantially performs, the other party's duties arise. Under the UCC, on the other hand, perfect tender is required, and only when the first party has delivered perfect tender does the other party then have to perform. So they like to make sure that you know that distinction between UCC and common law contracts. They also like to make sure you know the distinction between anticipatory repudiation and the prospective inability to perform. And often when they test this, a great answer will include at least a brief discussion of both. So maybe it's not quite anticipatory repudiation, which is an unequivocal manifestation that they cannot or will not perform. So without a question, they're not performing the contract. That's anticipatory repudiation. Prospective inability to perform, on the other hand, is when one party has reasonable grounds for insecurity that the other party might not be performed. They might be unable or might be unwilling to perform. So if you had the latter, prospective inability to perform, because someone has said, I don't know if I'll be able to perform under the contract, it's probably worth briefly discussing what anticipatory repudiation is and why this does not amount to anticipatory repudiation. Our sixth subject is corporations, which we discussed is now called business associations, and business associations technically includes agency and partnership and corporations. But when they do test corporations, some of the things we see them test include the duty of care in the business judgment rule. Directors are required to carry out their duties as directors on an informed basis, in good faith, and with an honest belief that their actions are taken in the best interest of the company. And the business judgment rule gives them the benefit of a presumption that they did these things. That means that the challenger, the person suing the corporation, has the burden of showing that the directors did not act on an informed basis, did not act in good faith, or did not have an honest belief that what they were doing was in the best interest of the company. They also test the duty of loyalty. A huge warning sign to alert you to as far as common mistakes is that you'll notice the business judgment rule goes with the duty of care. The business judgment rule does not apply to the duty of loyalty, so make sure you don't discuss the business judgment rule if you see a duty of loyalty issue. They also like to test piercing the corporate veil, and this is the idea that generally speaking, shareholders of a corporation are not personally liable for the corporation's debts or obligations. But under certain circumstances, courts may allow a plaintiff to pierce the corporate veil, pierce that veil of liability, and sue the shareholders directly or go after the shareholders personally. So this is another favorite topic of the California Board of Law Examiners. We've seen them test this a number of times. Now, don't forget, there's a note here, don't forget that corporations is actually part of business associations, and when they do a crossover where it includes both corporations and agency and partnership, oftentimes what they're looking for is whether the person acting on behalf of the corporation had authority. Because if they had authority, they can bind the corporation. The corporation is then the principal. So this isn't often how we see these mixed together. Topic number 7 is crim law and crim pro. Oftentimes they test one or the other, either crim law or crim pro, but it's not unheard of to see a crossover question where sometimes they'll ask, for instance, was this person's constitutional rights protected, and did they commit the crime they were charged with? So you'd have to discuss both. Crim law, they've tested a number of different crimes. They've tested the different degrees of murder. We've seen all the different degrees of murder come up. We've seen many different theft crimes come up in crim law. They've tested inchoate crimes or incomplete crimes like attempt and conspiracy and solicitation. And it's also very common that they test more than one of these at a time. So for instance, you'll see within the green dates that some of them have the same green dates next to them. That means that you are expected to discuss multiple of these crimes within a single essay. Within crim pro, their favorite things to test are the Fourth Amendment and the Fifth Amendment. Fourth Amendment search and seizure is a very commonly tested topic. And because it's commonly tested, there's often a specific way that they're looking for you to approach the topic to get full credit for that particular issue. So we see them test Fourth Amendment search and seizure, and we also see them test the Fifth Amendment Miranda rights. And again, because it's commonly tested, there's a very specific way to approach that particular type of question. So really crucial that you practice some Fourth Amendment and Fifth Amendment questions as you're studying for the exam. Our 8th topic is evidence. Evidence is often viewed as one of the most difficult subjects tested on the essay portion of the exam. The first thing that makes it difficult is that in evidence, they test both federal law and California law. And they will tell you at the end of the fact pattern to usually discuss one or the other. So about half the time they tell you to discuss federal law, and the other half of the time they tell you to discuss California law. So this is definitely one where you do want to be aware of the California distinctions for evidence, and there are a lot of them because they are pretty highly tested. The other thing that makes evidence questions hard is that the answers tend to be really long. There have been evidence questions with as many as 30 to 35 potential issues for you to discuss. That's 30 to 35 mini IRACs for you to include in your answer. That's a lot to get through in an hour. So for evidence, it is crucial that you be familiar with the substantive issues and the way that they expect you to set up your answer to this question. Because there's often a lot of patterns that we see as far as what issues you need to discuss for different types of evidence that we see presented in the fact pattern. One of the things to remember is that they almost always expect you to just start with a discussion of relevancy. And that includes whether the evidence is logically relevant and then whether it's legally relevant. This is almost always an issue for every single piece of evidence that is ever tested on any evidence essay. If it's a California law evidence question and it's a criminal case, you also want to remember to start out by mentioning Proposition 8, which allows additional evidence into evidence in criminal cases in California. Of the substantive issues, hearsay is one of their favorites. When they test hearsay, not only is it important to identify what is hearsay, that hearsay is inadmissible unless an exclusion or exception applies, but then also to discuss all of the potential exceptions that might apply. You may see a piece of hearsay and think this is clearly a party admission or an opposing party statement, and so you're going to discuss it as an opposing party statement. If it is possible that it's also a present sense impression, an excited utterance, and a statement against interest, you probably need to also include a discussion of those as well. So you can see how the issues quickly add up here in evidence and how there would be a lot to discuss. Some of the other things that they like to test include authentication. We see this coming up with documentary evidence, impeachment, and witness testimony. Oftentimes, if a witness is testifying, you have to explain that the witness has personal knowledge if they're a lay witness, or that they're qualified as an expert if they're being asked to testify as an expert witness. The ninth topic is professional responsibility. This is by far the most highly tested subject on the exam. So because it's highly tested as a subject, we've seen them test this a lot of different ways. There's a lot of different things that they could test in a professional responsibility question, and they test them all. So there's a lot to learn here. Also, this is a subject that we commonly see crossed over with other subjects. It appears a lot of times as a crossover with business associations questions, where that corporation has an attorney and they ask some of the ethical issues with regard to an attorney's representation of a corporation, for instance. It also comes up in community property quite a bit, where we see the attorney representing, let's say, a husband and or a wife in a divorce matter, and there are ethical issues to discuss within that community property question. As you can see here, there are many different issues that come up in professional responsibility: fees, communicating with a client, current client conflicts. And if you notice under current client conflicts, we've identified both the ABA rule and the California rule. And this is something else that makes professional responsibility a tough subject. California often ends a professional responsibility question with the call of the question: identify any ethical obligations or ethical misconduct under both California law and the ABA model rules of professional conduct. So this is unlike evidence where they pick one or the other and expect you to apply that one that they've identified. Here for professional responsibility, they almost always ask you to discuss both the model rules from the ABA and the California rules. So you do need to be familiar with the California distinctions from the model rules, especially in those places where an attorney's misconduct would have different consequences under the ABA rules versus the California rules. One of those places that we see that comes up in a lot of professional responsibility questions is the duty of competence. And just a quick note about this particular topic: even when it's not directly tested, almost every professional responsibility answer, the good high-scoring student answers, throw this in as a topic and just briefly discuss whether the attorney has acted competently. Our next topic is real property. One of the things they seem to love to test here is landlord-tenant law, and they test it different ways. They test different types of leases, so a tenancy for years versus a periodic tenancy and a holdover tenancy, and the type of notice that has to be given for each of those different types of tenancies. They also test the duties of the landlord and the tenant. The tenant has a duty to pay rent. The landlord cannot evict the tenant. They test assignments and subleases, which may come up in a landlord-tenant scenario. So as you can see, they really like this scenario with landlord-tenant law and leases. Another one that they test, which you saw at the top of this list, is joint tenancies and tenancies in common. including how to create a joint tenancy and how to sever a joint tenancy. Our 11th topic is remedies. Remedies is another one that is commonly crossed over with other subjects. We do see it tested on its own, but we've also seen it many times crossed over. And when they cross it over, it's crossed over with a lot of different things. Sometimes it's crossed over with contracts, sometimes with torts, sometimes with real property. They recently tested it as a crossover with constitutional law. So we kind of see it crossed over with everything. The common things that they ask about in remedies are tort remedies and contracts remedies. And they may or may not call it a crossover question. You could have a question that is just remedies, and they focus on tort remedies, or they focus on contracts remedies, or they focus on both, but they just don't label it as a crossover. So just be aware that remedies questions might include facts from what appear to be other areas of the law. Within remedies, they test both legal remedies and equitable remedies, and it's often a good idea to think about both. At the end of a remedies question, it'll probably be something open-ended, like what types of remedies can this person seek? And so it's up to you to go through all the possible remedies that that person may recover. So if they're suing in tort, they may recover legal remedies or money damages. And this could be compensatory damages, punitive damages, restitution damages. They may also seek equitable remedies, such as a constructive trust, an equitable lien, a TRO, a preliminary injunction. So it's a good idea to have this kind of list ready to go in your head of all the possible remedies you may have to discuss. If they do test equitable remedies, it's often a good idea to discuss equitable defenses. They may or may not be applicable, but you probably want to include at least a brief discussion of them at the end of your essay. Our 12th topic is torts. Negligence is by far their favorite issue to test. And when they test negligence, they often are looking for a lot of detail in your negligence answer. So you want to be able to discuss all the detail necessary for instance, duty. One of their favorite to test here is premises liability and all the potential duties that are owed depending on the status of the person who was injured, the status of the plaintiff. So was it an undiscovered trespasser or a discovered trespasser? Was it a licensee or an invitee? These are all things that they like to test, and they show up quite frequently. They've also tested within negligence per se. And if they test negligence like this, it's important to include as much detail as you can on things like the duty, actual cause, proximate cause, damages. This is probably one that's going to need some sub-parts to your IRAC. Rather than just having one giant IRAC for negligence, you may need some sub-IRACs in your answer for the different portions or pieces of negligence. They've also tested intentional torts a few times, not as highly as negligence, but they've come up. Products liability we've seen tested a few times. When they test products liability, they're often looking for a very certain response. They often look for you to discuss whether the defendant is strictly liable for the defective product, or could the defendant be negligent for this defective product, and you often need to include a discussion of both. And then nuisance is also highly tested, but actually they test nuisance as a property question. So if you see nuisance, it usually comes up on the real property questions. So those green dates identified here are actually real property essays that tested nuisance. Trust is another topic that we are expected to discuss California law. Some of the common issues we see come up in trust include the validity of a trust. Are the elements of a valid trust present? And this is a preliminary topic that often needs to be mentioned in many different trust essays. It's usually a good place to start with a trust question. Within the types of trusts, we see them testing testamentary trusts, or in other words, a trust that's created within a will. And sometimes here they'll do a crossover between wills and trusts. So you have to analyze the will and sometimes see if the will is valid, and then also analyze the trust and some trust issues that may come up as a result. They also like to test charitable trusts. And in conjunction with charitable trusts, they often bring up the cypre doctrine, which is the doctrine that allows the court to modify a charitable trust if the charitable purpose has become unlawful, impracticable, or impossible to achieve, no alternative charity is named in the trust, and the court finds that the settlor had general charitable intent. If these elements are met, the trust won't fail because the purpose became impossible, but instead, the court will rewrite the trust to try to achieve that general charitable intent. They also sometimes test duties of a trustee, such as a trustee's duty to administer the trust, the duty to account, the duty of care, duty of loyalty. Those often come up with the trustee who's administering the trust. Our final topic is wills. One of the things they actually test here is intestate succession, which is what to do if there is no will. So not only do you need to know about wills, but you need to know what to do if the person has not created a will. They do like to test, though, execution of a valid will, the requirements of a will. As we saw on the trust topic, if they test a testamentary trust, often you have to go through these requirements of a valid will and then also analyze the trust at issue. Within valid wills, they've also brought up a number of times things like holographic wills and whether they are valid. And in California does recognize holographic wills. Not all states do, so they want to see that you're aware that California does recognize this. In codicils, which is a modification to a will or a supplement to a will, and so they want to see that you understand that those formalities of a will have to be followed for a codicil as well. They've also tested revocation, how a person revokes or cancels their will, and the pretermitted or omitted child doctrine, which is what happens when a person has a child that was born either before the will was written or they didn't know they had a child and they wrote a will. What does that child take? And they will take despite the fact that they were not included in the will. Wills and trusts are, like I said, often tested together, and another way we commonly see them tested is crossed over with community property, where you do need to know some principles of community property. If you have an issue where a husband and a wife had a will or didn't have a will and died, how do those community property aspects play into how the property will be distributed? So those three topics actually often get mixed together to an extent: community property, wills, and trusts. So I hope you find this helpful and you can utilize this to tailor your studying to those highly tested topics on the California bar exam essays. When California tests something over and over, they're presuming that you understand how you should address that issue because you've probably seen it tested as you did some practice essays. So for these highly tested topics, it is so crucial that you have a firm grasp on not only the material, but also how to approach it. So you can utilize this, and especially those green dates, for each of these highly tested topics to make sure you understand exactly what to do if you see one tested on your bar exam.